It's 23B00981-3, State of Georgia versus Austin Tybee Ford, before the court for status and or sentencing.
And the state's position?
Your Honor, with a heavy heart, this state is announcing that it is not going to proceed with a third trial on counts 1 through 5 in the State of Georgia versus Austin Tybee Ford, and the state is asking that he be sentenced on counts 6, 7, and 8 after being duly convicted of those matters at the conclusion of the first trial.
All right, and Mr. Norris Lewis, on behalf of Mr. Ford, are you prepared with that announcement to go forward with sentencing this morning?
Yes, Judge.
All right. The first jury having reached a unanimous verdict solely as to counts 6, 7, and 8, count 6 being theft by taking, count 7 being theft by taking, count 8 being concealing death of another, and the court having declared a mistrial as to counts 1 through 5, and a second jury having heard evidence in the case and being unable to reach a unanimous verdict on counts 1 through 5, the court is left with sentencing solely as to counts 6, 7, and 8. I will hear first from the state with any evidence in aggravation and any other relevant evidence you want to present with regard to sentencing.
Your Honor, the state does not have evidence in aggravation in as much as this defendant did not have a prior criminal record. There are victim impact statements, 4 that I expect will be spoken if the court would like to take them now or after any evidence in mitigation is given, as well as the state does have a recommendation.
Okay.
Your Honor,
let me hear the recommendation in first, please.
Your Honor, the sentence range for counts 6, 7, and 8 is each 1 to 10 years to be as the court sees fit. The state is recommending a sentence respectfully of 30 years and that to be served in custody, a sentence of 10 years on each count to be run consecutively to each other. The state's position and the reason for that understanding that he was not convicted of counts 1 through 5, that the theft of the vehicle, the theft of the gun, and concealing the death of another in the manner in which it was done was concealing the death of Tori Lang, one that, by his own admission, he at the very least was aware of. This defendant spoke with her family members. He went to her funeral. He initially contacted Tori's mother, and when he knew what had happened to Tori, when Tori was just missing as far as the family knew, when he knew what had happened, he said nothing. He pretended to look for Tori. He pretended to be a concerned friend, knowing that he disposed of the weapon that she was killed with. He disposed of her vehicle. He continued to conceal any knowledge about Tori's death until he was finally caught in a number of lies by Detective Carter, but not till months and months later. This is having talked to her mother on the phone, after having gone to her funeral, after having pretended to be someone who cared about her and was concerned about the family's grieving. It is malignant and heinous to behave in that manner, and thus add to the grief and to the wrong that has been done to the Lang family. So the state does respectfully ask this court to sentence this defendant to the maximum possible sentence and ask that it be served in the custody of the Georgia Department of Corrections.
Okay, 2 questions. Is a 30-year to serve sentence in line with what the state would normally ask for these 3 charges for someone with no prior criminal history? I mean, is that in line with what you would recommend in a case where somebody has been convicted of these charges?
Under these circumstances, yes. He's, though not convicted, of being the direct perpetrator of her death.
Nor can I sentence him for that.
And I'm not asking you to, because the jury has spoken. They were unable to reach a verdict. Two juries were unable to reach a verdict on that, and the state's not asking this because it could not secure a conviction on the other counts. But the state is asking that you consider the level of grief and strife that was visited upon the Lang family by this defendant based on the offenses even for which he has been convicted, and how not knowing knowledge of her death and knowing that a close friend of hers had knowledge of her death at the very least for months and failed to share that with the family allowed them to spend at least 2 days not knowing what had happened to her at all, then to find out that she had been shot in the head and he left her in Yellow River Park. And that is what he is convicted of. And I do believe that the sentence the state has requested is appropriate based on the facts and circumstances here. Obviously, each recommendation made by the state is made considering the entire body of facts and circumstances. And though he has no prior criminal record, that does not mitigate how heinous his actions actually were and how they impacted the Lang family.
All right, have you prepared a non-pros for the court on the prior indictment 22B03732-3?
I will provide the court with one, yes.
All right, that will need to be provided today.
Yes, Your Honor.